It's always nice for an attorney to be introduced to such a large group and not have it involving booze and hisses. So that's a good start. You can usually tell the attorneys in a gathering like this because we're the ones that have the suits on. And you know why that is. It's to cover the dorsal fin. I have a little bit of a challenge today. One, I'm obviously following a fantastic speaker who had the pleasure of talking about how you guys make money, which is probably the biggest thing on your minds. I get to talk about risk and how you might lose money and have costs with us attorneys. So, and also get to do it after lunch. So I'm going to do my best. What I've done today is to try and distill what's essentially an entire first-year class in law school on commercial law into the highlights that may affect your relationship with your customers and some pitfalls to watch out for that you may see in your master service agreements, with your master purchase agreements with your customers and other agreements with your customers, and what they mean and what we can do to minimize risk or at least control it and know it's there. The area of law we're talking about, you may have heard of this before, but it's the Uniform Commercial Code. I'm going to wander around a little bit, but I just want to make sure. Can everybody hear me in the back? For a lawyer, I can be a little bit soft-spoken. It's kind of an occupational hazard of mine. Uniform Commercial Code is it's a uniform body of law. Shocker is what's right in the name. It's designed to promote uniformity and certainty so that lawyers sitting in Kansas City can know what the law might be in New York. There's a little bit of debate about whether it's actually in all 50 states because Louisiana is, in most areas of the law, a little bit different. So if any of you are in Louisiana, you've probably heard that before, and their Uniform Commercial Code is slightly different. But the law professors who drafted this code, their goal was to take the law away from the 18th, 17th century view of the common law and try and make the law match business reality. What is actually going on in the business world? That was, I think, a laudatory goal, a good goal, but they're law professors. They did the best they could. The good thing we have is it's a template. The UCC is kind of the default settings, the basic ways contracts will work, arrangements will work, expectations among contracting parties. But it isn't necessarily a hard and fast rule. That's good in some ways and bad in others. And it's bad in some ways because if you're negotiating with another party, you can modify the law. And if you're not the party with the most leverage in the deal, you may not want that so much. And the way we see this in master purchase contracts causing the most consternation is what lawyers call remedies. What happens when it goes bad? Of course, that's the first thing lawyers think about is, well, what's the downside when this arrangement goes to pot? And like I said, it's a template. So what the UCC giveth, the UCC taketh away. So if you have a right under the UCC, your contracting partner can take that right away from you. For the most part, we'll see some exceptions up ahead. So your customer can tailor the remedies that are available to them to their favor, and they can take other remedies that you might have available away from you. Here's a good example of a damages clause. This is actually from a real signed master purchase agreement that is out there in the industry. Suppliers shall be liable for all damages, no limitations, arising from supplier's failure to perform, including direct and indirect damages. Now, in the ordinary course of business, you look at that and say, okay, I have no idea what that means. I've seen boilerplate in a million contracts, whatever. But what it means is the UCC has this thing it's created called indirect or consequential damages. And what those are not just the normal breach of contract damages. Hey, I bought a $400,000 piece of equipment. It doesn't perform up to expectations. I want a refund. I want you to take it back and I want my money back. Or conversely, hey, buyer, I sold you a $400,000 piece of equipment. You've only paid $200. I'm suing you for the other $200. What this is any kind of damage that you might have a reason to know of at the time you sold it, including an injury to a person. And that should send some alarm bells up. Uh-oh, somebody gets hurt, I could be liable. Here's an example from an actual case out of the Third Circuit, which is the Federal Court of Appeals out in Philadelphia. This is a new grocery store, never been in business before, had no history of anything, had never even opened. We had no idea how much business this grocery store is going to do. They bought a rather large refrigeration unit. A unit never worked right. They never got the grocery store open. They didn't get it open on time. It ultimately ends up getting replaced. and it delayed the opening of the store. It's a $400,000 unit. The jury gives them $1.5 million. So your $400,000 deal ends up as a negative $1.9 million essentially, because they had to pay back the $400,000. The damages included a $1 million amount in lost profits. You should have, supplier, you should have known that if your refrigeration unit didn't work correctly, you would have caused us to not be able to open our grocery store. Our grocery store can't operate without a refrigeration unit. And they went out and found themselves an economist who would testify that this grocery store in this neighborhood would have had $1 million in profits in the 2 or 3 months delay. Profits, not revenues, profits. And ultimately the jury bought that. Another example was a case out of Ohio where a buyer purchases a machine that was supposed to wrap hamburgers in wax paper. The machine worked. It's better than a refrigeration unit, but it never really worked right. There was a lot of repairs, and it ultimately was replaced. They get the replacement value, the plaintiff suing the customer. They get double the cost of the machine because of repairs, and they get their lost profits on that. All of those are things the court said, well, at the time you made the contract, you knew if you didn't perform, you didn't give them the machine they wanted, you could have reasonably known that those damages could have occurred. And of course, the personal injury is the worst case scenario. As we hear more and more about outbreaks, salmonella, more and more it gets into the public conscience, and more our friends, the plaintiff lawyers, are using these as ways to bring suit. We're going to see claims for personal injury. And as you saw earlier, that's a form of consequential damage. As an example here is a case out of West Virginia, actually a little bit of an older case. Anytime you hear the words bad vending machine cheeseburger, some kind of a red alarm should go up. But this fella bought a vending machine cheeseburger, got sick, and ended up getting, I believe his damages were in the hundreds of thousands, and they sued back to the supplier. The issue there was that the vending machine refrigeration unit was not up to snuff, so they got back and sued not just the vending company, but the supplier itself, who was on the hook for several $100,000. Now, in the law, there's something called assumption of risk, which means that if you assume the risk of some bad thing, you can't sue for it. And I would suggest maybe buying a vending machine cheeseburger is an assumption of risk. But the risk involved in these personal injury cases are serious. I looked up the figures to see exactly how many people are out there. I tried to find figures on how many food poisoning lawsuits are filed. I don't know if the plaintiff's lawyers really want us to know that, because it was extraordinarily hard to find. We have a specialist who researches those types of things and jury verdict awards and things like that. And he couldn't find it online or anywhere else, which makes me think there may be a reason for that. But according to CDC, at least, there's 5,000 people a year who die from some type of foodborne illness, 325,000 hospitalizations, and at least 76 million, that number shocked me, a year, people getting sick a year from foodborne illness. And the reason the CDC says the number is so high is most people don't realize it. Couple of really nasty judgments. One is an $8.1 million that KFC got from food that was not properly refrigerated, that caused salmonella, that caused a serious brain injury to a young girl. And then more recently, an organic peanut butter company was hit with a $2.1 million verdict for a food poisoning death that came out of their peanut butter making process. And everybody there was involved too, not just the company, but the suppliers. And the one that's scary is that $2.1 million number is from a jury in West Texas. And that's not exactly, I mean, there are places around the country where lawyers know we get a complaint in from certain jurisdictions and it's, this is not going to go well just because of the jurisdiction. West Texas does not strike me as, from experience, as a place where jurors are off the rails or not conservative. So there's some serious risk involved in consequential damages. So what can you do? Well, again, the UCC is a template, so that's our starting point, so we can change some of these rules. You have an explicit right to limit or exclude remedies entirely, and that includes consequential damages. Generally, to take off a remedy off the table, something that would be in the contract as something you could sue for, You have to at least make it so there's some remedy in the contract. The key words in UCC are fail of its essential purpose, but translated that into lay speak is you can't take all remedies off the table so that if there was a breach of contract, you're just out of luck, which is good, and for both ways, because that means our purchasers can't do that to us either. Now, query whether it's really practical to say, I'm going to go back to one of my bigger customers and say, hey, this new contract I want you to sign says no consequential damage at all, ever. They all have in-house legal departments for the most part if they're bigger companies. If not, it's still going to send up a red flag. So I try and be realistic in these presentations because I want to give you practical advice. And to sit here and say, you should go back to all your customers and say, I want to waive consequential damages in all my contracts. I think your customers would be scratching their heads. But there are smaller measures you can take that don't send alarm bells that maybe something you can actually negotiate. And one of those is to limit the subject matter of what you can obtain consequential damages for. Hey guys, you're the ones selling this product. You're going to be the ones responsible for personal injury, for instance. Or you can create a dollar amount cap. I mean, that might have helped in the situation of the $8 million verdict. But those are things that I think are a little more palpable to customers that certainly the UCC would allow you to do. But it works both ways. This is something I've foreshadowed a little bit. As much as you can limit your own remedies, the sellers can do things to, as much as you can limit their remedies, they can turn around and do the same thing to you. Here's an example of a damages contract in a master purchase agreement. Again, this is a real contract that actually signed being used in the market. Purchaser may, at any time, and for any reason, cancel goods and services. That means you get no notice. You get an email on a Friday night at 5 o'clock, your contract's canceled, I don't want any more goods from you, and I don't have to give you a reason. The only remedy against purchaser is reimbursement for its reasonable cost of manufacturing. So reasonable is one of those words when you see in a contract attorneys love, because that means we get to argue about it. Well, what's reasonable? It doesn't mean that I'm automatically getting all the expenses I put into getting you whatever goods are left on the contract, because you do have a right under this to what's left, what you've actually got. If you've got something sitting in the warehouse that they've paid for, they owe you for that. But you only get a reasonable amount. So we get to argue, instead of what you actually put into those goods, what was reasonable to put into those goods. And the best part about it is the last clause, provided supplier, us, is not then in default. Which sounds harmless enough. Well, I'm not in default on my contract, until you look at the legal language used to define the word default, which is usually any variance from the contract at all. You're 1 day late on a shipment you made 6 months before. That could very well, under most supply contracts, be defined as an act of default. And so under that language, what do you get if you're in default? You get a goose egg. You get absolutely nothing, the way that contract's written. You don't get any. You could have goods that you've shipped, goods that you've manufactured for these folks, time you've lost on them. You're not getting anything because you're the one in default. And oftentimes, if you try and sue them, they'll turn around and sue you for the default. So that's a nasty clause. I can't emphasize enough how onerous that is. So the question is, what can we do? Well, if we had the ability to work with our customer and negotiate these terms, the first thing I would do with that term is to try and get some kind of notice. I mean, even if it's a week, it gives you some opportunity to mitigate your damages, and more importantly, get your salespeople in there and say, well, what's going on? Why are you guys so upset at us? Why are you terminating our contract? And try and remedy it. And of course, make it for cause. I mean, at least that gives you a fighting chance in litigation, for one thing. If it's for any reason, they can pull the rug out of you any time, and the contract's going to allow it. Certainly, the UCC will allow you to do that. But another good thing about making termination for cause is that they're going to probably talk to a lawyer ahead of time. And he's going to say what all lawyers do, is to say, I can't give you a clear answer. It'll depend on what the judge says. And so they got to think a little bit before they're going to terminate your contract and pull your rug out from under you. And require reimbursement of all the costs. Don't make it reasonable costs. Make it the actual cost that you expend. Anytime you see the word reasonable in a contract, it's a point of debate. It's one of those things that lawyers know as a buzzword that means something you can't decide with any kind of certainty, so there's going to be arguments about it. And probably most importantly, ask for a chance to cure a default. Cure is another little magic word of lawyers, which is that if you think there's a default, you have to give us notice and tell us why you think we're in default of a contract, why we're in breach. And give us an opportunity, 30 days, 60 days, some opportunity to fix it. So that way you don't get that nasty surprise of the email at 5 o'clock saying, we're out of here, we've got a better price over here, and we're going to pull this contract out, and you've got no remedies against it. I'm going to talk about some other pitfalls that purchasers will throw into contracts. One of them, they're liquid damages, specific performance, indemnity, and waiver of acceptance. It's a real murderer's row of boring legal terms, but each one is dangerous in its own right. Liquidated damages sounds like you get damages in the form of a liquid, but it's actually a set amount that you pay in the contract. So we set a contract that says, hey, you breach, you owe me $1 million. You've probably seen that in the contract, maybe not. They are enforceable in almost every jurisdiction. This is one of the ways the UCC waivers a little bit. It's supposed to be uniform, but in some jurisdictions won't let you do this, some will. The key is that the amount can't just be random. It can't be, if you're selling a $400,000 piece of equipment, it can't be $1 billion in liquidated damages. I mean, there's no jackpot. I mean, you have to actually have it connected to what the cost of the equipment was, the harm caused by your breach. You know, the difficulties of proof of loss, meaning that it just would be a hard case to prove exactly how I'm injured. The liquid amount is just kind of an approximation of that. That's fine. Otherwise being able to have difficulty getting an adequate remedy. It's kind of legal terms, but so there is a little bit of argument about whether they're enforceable, but generally they are going to be. And so if you have a purchaser throw into a contract language that says you owe, if you're in default, and remember we just talked about how narrowly default can be and how silly it really can be under some contracts where it demands really strict performance, you can owe a certain liquidated amount. Specific performance, this is the idea that in a contract, instead of, when something goes wrong, instead of suing for breach and asking for the money you think you're owed, you sue to actually enforce the contract. It doesn't come up quite as much in this context as some others, because generally the buyer will, if they're at a point where they're saying you breached the contract and I'm going to want my remedies, the relationship's such that they don't want your product. But it is a disaster if it does come up. Instead of money damages, what you're going to get is a court order saying you have to turn over, you have to perform the contract. You have to give the equipment that they specified. I have down here at the bottom the Kodachrome example. There's way too many complicated facts to put into one slide. But this was going back a few years, and Kodak was getting out of the Kodachrome business. And they had one customer who had a really long-term supply agreement. And Kodak was shutting down one of its few Kodachrome facilities, and it was the one that was providing, and frankly, if I recall the facts correctly, it was the only customer left for this one factory. And Kodak simply couldn't afford to keep the factory, and they were shutting it down and basically saying, hey guys, we're going to breach your agreement, thinking they were going to get sued, and they would just chalk up whatever the damages were as cost of doing business. And it didn't quite work out that way. The folks who needed the Kodachrome film needed a lot of it. It was their lifeblood of their business, and it was complicated as why, and I'm not going to try and recite it here. But they had a provision in their contract that says that one of the remedies, if Kodak should breach the contract, is specific performance. And a federal judge in New York City said, you contractually obligated yourself to specific performance as a remedy. You guys got to keep that factory open. You don't hear too much about Kodak anymore, and this ended up costing them tens of millions of dollars to keep a factory open they would have otherwise scuttled. And all because this contract said specific performance. So that's a buzzword that if you see it in a contract, you probably want to excise it, because generally courts are really hesitant to order specific performance unless you've agreed to it. At that point, all bets are off, and it can be a really bad situation for someone who is a seller of a good, because you never know what is going to happen to you in the end when you have a purchaser who had expectations that are not being met. Indemnity. This is another fancy legal word for basically saying you're their insurer. So here's an example of an indemnity clause in a master purchase agreement. Supplier agrees to hold harmless purchaser from all damage and legal costs incurred in respect of any claim arising out of the equipment. Now, I said earlier to a couple of these clauses, oh, that sounds harmless enough. That doesn't sound harmless. When you read that, even as a layperson, that should send up some red flags. So if they get sued, not only are you going to get to pay any damages in relation to the machine, if they get sued, you get to pay their damages, and you get to provide them a lawyer. So great for them. They're off scot-free. So indemnity clauses are a serious part of any contract. It can end up being a significant portion of risk you're taking on if you have an indemnity clause in your contract. And acceptance. Acceptance is actually a really good thing. This was one of those things the law professors who drafted the UCC came up with. Actually didn't exist in the common law, the law that existed prior to the UCC, which going back prior to like 1950. And what acceptance is that when you deliver your goods, your machines to your customers, they have a reasonable period. Oh, there it is again. There's that word. They have a reasonable period of time to decide whether the product's up to snuff or not. The UCC calls it nonconformity, but whether it satisfies what they were looking for. If they don't act, they don't send you the email or give you a call that says, hey, this isn't what I wanted, this doesn't work the way I needed it to, they're deemed to have accepted the contract. Accepted the good, and they can't sue for its non-performance. So this is a good thing for us. It means that you don't have this long-term risk, that at some point, the chance for them to complain about the product is cut off, or at least complain in a legal sense and sue you for non-conforming with the contract. The problem is that this is a right that can be waived, and we're seeing it more and more in these types of contracts, where there'll be an explicit clause saying, supplier hereby agrees to waive the right of acceptance. And the effect is to eventually allow your buyers to raise issues that could be 6 months old, could be a year old, could be 4 or 5 years old. There's a case out of Texas that is just such a horror story, where there was a waiver of acceptance language in a contract, and the supplier was in the oil industry, and they sold these extremely high-tech oil rigs, drills, and over a 12-year period, the customer used the drills, was a profitable oil company, and then decided, you know what, they should have been working at about 10 to 20% higher capacity. We're going to go ahead and decline these goods, and we'll sue you. And they won. And they won millions of dollars. I mean, that was a jackpot for them. They got all the money out of it. They used the equipment for 12 years and then turned around and sued. And because there was no acceptance, there was a waiver of acceptance in the contract, that was it. They ended up losing, and they got hit with a huge jury verdict. So at this point, I've thrown as much legal jargon as you probably ever wanted to hear. I've thrown the apocalypse of bad things. So I got to pull out the heavy ammo. There's my 5-month-old. If that can't put a smile on your face, if that guy can't bring you back and get you feeling better, there's nothing I can do. All right, so now, guy's charmed more rooms than I have, and he's 5 months old. Kind of smaller but not insignificant issues with your master purchase agreements. What I would call dispute resolution clauses. And these are agreements ahead of time to kind of manage what your disputes are going to be like. You've probably heard of some of this. I would suspect most of the people in the room have heard of arbitration, maybe have been through an arbitration at one point or another. A more trendy type of dispute resolution is mandatory mediation, which is great. Mediation is supposed to be a negotiation process where you negotiate a dispute with a third party, and you try and come to an acceptable resolution, which makes it kind of, this is kind of one of those oxymorons, and mandatory mediation, so this is a mandatory settlement process. I mean, they don't really work together. But and then choice of law and choice of forum, which are classic boilerplate, small type at the bottom of a contract that you wouldn't even think twice about most of the times in signing, but it's usually one of the first things your litigation attorneys would look for. So let's go through each one of these quickly. Arbitration, the idea here is that there are too many cases in courts, and most commercial entities don't want to be in court. I think that's true for the most part. How many times have I said, and then the jury did this today, $8 million, $1 million, $12 million, those are all jury verdicts. So, if we have an arbitration clause, we don't get a jury. We don't get hauled into federal court somewhere and deal with the difficult process of discovery, which if any of you have been in litigation and know what modern discovery is like, let me give you a little example. You can, yeah, I can see a couple smiles around the room. Every email you've written to this customer is going to be discoverable. Your tech guys are going to be going back and getting backup tapes for your emails going back to 2000, 1998, whenever the contract was signed. You're going to take depositions, meaning you're going to be sitting in some conference room somewhere getting grilled by some guy like me, or probably someone less nice. You've got all these bad things about litigation. So arbitrate, this is one of those ones. All the clauses we've talked about today, I can uniformly say, oh, these are bad, or oh, these are good. Arbitration, this is a 50-50 proposition. In most situations, you probably want it because it's quicker. You get to a resolution much quicker. You have little to no discovery, so you're not going to be spending 2 years fighting about what information you can get from the other side, sitting in depositions, having your key people wasting their time pulling through emails instead of doing what their job is. Yeah, the downsides are the process is fast, which sounds good, and then you think about, well, in my context, if I've got arbitration and I'm the one being sued, meaning you're being sued by your customers, well, they've got all the information. They're the ones that know what's going wrong with the machine. They're the ones that know how it's malfunctioned, and they will have spent weeks gathering all their facts, getting all their witnesses in a row, and then lo and behold, you'll get the arbitration demand in, and you'll have an arbitration 2-3 months down the road, and you'll have no idea what they've got up their sleeve. That's a little dangerous, and that's what the discovery process in normal litigation is intended to cut against, kind of the imbalance of information. So that could be a bad thing. You've got no right to appeal, and it's oftentimes just a single decision maker. So you'll get, as professional arbitrators, or sometimes just lawyers, will serve as kind of a private judge, for lack of a better word. And they know they're not going to be reviewed by the courts. So oftentimes what an arbitration will come down to is, I refer to it as the wild, wild west of decision making, because the arbitrator is going to do what he thinks is fair. He's not going to be bound by what the contract says. He's not going to be bound necessarily by what the law is. He's going to look at it and just take a look at this party over here and this party over here and decide which one seems like the good person, which one seems like the bad person, and that's the person who's going to win. And I just distilled arbitration down to its essence. So next time you get an arbitration demand, be terrified. Mandatory mediation, I've kind of previewed this a little bit. This is really trendy right now in contracts, and I'm seeing this pop up more and more. And what it is it's an automatic circuit breaker before you get to litigation. And again, this is one that's a little bit of a 50-50. A lot of times people are angry when a dispute's arisen. We've got a relationship that's gone sour. If lawyers are involved, the customer relationship's really gone to pot. And so calming people down, getting a third party involved who can say, hey guys, here's what your downside risks are. Because sometimes your own lawyer has a duty to you to tell you the truth. I mean, it's the hardest part of our job, and one a good lawyer will take seriously. It is, we do. We have an obligation to tell you the truth. And that includes not telling you what you want to hear, but also telling you that, hey, if you bring this lawsuit, you got a chance of losing. They brought this lawsuit, if you're defending it, and sometimes it's the hardest thing to tell your client, they got a chance of winning that. It's not always easy to tell your client what they don't want to hear. Getting a mediator involved, especially early in the process, can cut against that. And plus, you have a chance of settling the case before you ever incur all these expenses. That's always a good thing. But also, you're negotiating without leverage. You've got, much like the arbitration situation, if you're defending a case, if you're the one being told by your purchaser that your product's not working, they've had all the time in the world to gather up all the facts, and they'll come to the mediation knowing everything they need to know to bring the case. And you're going to be learning a lot of things for the first time there. So being able to respond to that on the fly and mediate successfully, it can be a little bit difficult. But if you get into litigation and start throwing discovery at them and getting up to speed and getting a little pressure on them and making them do the work, maybe you got a little more leverage. So mandatory mediation is a little bit of a 50-50. Sometimes it can be a good thing. It's not something I would necessarily say I would excise from every contract. Choice of law and choice of form. Again, I think these are things nobody ever really thinks about, but can really, really materially affect you once you get into litigation. They're like, first note, almost always enforceable. And the great example I have on that is a case we had involving a financing transaction that went really far south. And we had an arbitration clause for the island of Guernsey. Let me ask, how many people in this room know where Guernsey is? Oh, I'm impressed. Oh, very good. Well, I didn't. I am ashamed to say I had to look it up. I'd say that's about half the room knew. Never mind. But yeah, this was a Texas company financing a Missouri company and also suing a New York law firm. And they had to go arbitrate in Guernsey. So, you know, there's one small, we were joking at one point, it's like, how are we going to find a hotel in Guernsey? Because we're all going to want to stay at different hotels. You don't want to be seeing opposing counsel every day. But we ended up settling the case, so I was kind of disappointed because, you know, I really wanted to go to Guernsey. But the second point is a real serious one. Do you really want to face a judge or jury in a faraway place where you're going to have to haul all of your people to? Well, all your key players on the other side are going to be from that place. And more importantly, you know, your judge, jury, witnesses, you know, they're all going to be people who know that company. I mean, I can think of, I'm from Indianapolis, so I can think of Eli Lilly as a great example. I mean, you couldn't shake a stick at somebody in Indianapolis who doesn't have a relative who works at Lilly. I'm sure most major cities are that way. So they have a considerable home field advantage. Now, getting a choice of forum clause excised from a contract is pretty hard. You know, it's something that would probably raise a red flag, and maybe it's not worth the fight. But that's really the consideration there. And choice of law can be fun too. You never know what's tucked in the law of certain jurisdictions. I mean, I'm thinking of, I can imagine that Michigan has favorable laws for the cereal industry, for instance. I can't imagine Minnesota doesn't have certain laws that protect some of their big. I'm thinking of Hormel. I know Indiana's drug protection laws are interesting, and not the least of which because one of our biggest employers in the entire state is located there. And I took a case up to a state Supreme Court not too long ago over a fight on choice of forum, you know, whether we were going to fight in Indiana or Las Vegas, because we were suing two Las Vegas casinos. And they wanted to be in Las Vegas because they knew they were going to get Las Vegas laws. And oh my, the Nevada law was different than Indiana's on what casinos could collect and couldn't collect. What a surprise that was. I would be remiss if I talked about the UCC without talking about warranties. The UCC creates a bunch of warranties that are really probably its touchstone feature, and something you see the most discussion and litigation about. Express warranty is pretty straightforward. It's really any affirmation of fact or promise you make. The third one is one people don't think about as much. That if you provide a sample, or you know, here's what your product will look like, or a model, that's actually a warranty. You don't really think about it that way. But if you show your customer a model and show your customer how it works, you're actually warning that the product you're going to sell to them is going to work the same way. And you can be sued if it doesn't. Well, the UCC came up with two other things. This was an invention of the law professors. And their idea was there's certain commercial expectations that go on between business transactions. And we want to make sure that those are enforceable. And one is the implied warranty of merchantability. That's a gobbledygook word that means that the product works the way you would normally expect it to work. The example I always give for this is think about an air conditioner, a window unit. If you bought a window unit, you would expect that window unit to cool a room. You wouldn't expect it necessarily to cool the whole house. So if it fails to cool the whole house, you can't really sue for implied breach of merchantability because that's not what that good's meant to do. But if it fails to cool your room, well, you've got a different story. That's the general purpose of which those are used. The implied warranty of fitness for particular purpose is a long way of saying that if you have a long discussion with your customer and they tell you that, hey, outside of what that unit's normally supposed to do, I have X, Y, and Z expectations. I tell you, air conditioner manufacturer, I expect this unit to cool my entire house. And you say, oh yeah, it'll cool your entire house. Well, now you've made a different warranty. You've made the warranty for a particular purpose. That you know your customer has a particular purpose and you're warning that it can in fact carry out that. These cases that get litigated on this are always the classic, we have a failure to communicate situations that the customer said, I expected it to do X. And they never told me that. I mean, every customer, every client I've ever had that's been sued for this particular warranty, I had no idea that's who. I would have told them no in a heartbeat. So that's kind of the way that goes. How can I limit these warranties? Well, again, you can say to your customer, hey, you don't get the implied warranties under the UCC. Dude, that sounds a nice red flag. I'm not going to warranty that your good will work as it's supposed to. Or I'm not going to warrant that all those things you just told me you're going to do are actually going to do. You're not going to sell too many goods if you're disclaiming those. Although you'll see this all the time in consumer contracts where, in the tiny boilerplate at the bottom, it'll try and disclaim those two warranties in a contract where there's not really a contract. But in one where you actually have sophisticated parties involved, if you have a contract that tries to disclaim the implied warranties, you're generally going to get a big no and a big red flag with your customer. So again, I go to the bottom here. Well, okay, we can't go for the home run. It would be great if we could disclaim these warranties and make it a situation where we couldn't be sued for breaching them. But is there more practical limitations? Can we limit the remedies that are available? Sure. You could put a cap on damages. You could make a repair and replace so that if, okay, I sell you my $400,000 piece of equipment, you can't sue me for all the consequential damages like we talked about, but we'll come out and repair and replace. And that's your limitation on the implied warranty, that we'll come out and fix it. And that's generally much more palpable. And frankly, you can phrase it in the contract so it actually sounds like you're getting something and not necessarily getting their warranty taken away. So that's my last slide, and I'm not really sure how much time we've got left, but I'd love to take questions from the group. Yeah, absolutely. Sure. I don't know yet. I almost want to say that's a great law school exam question to try and piece that apart. I think you're probably more likely to see that disputed amongst the lawyers under the first provision, that you're making affirmations of fact in the video, that I'm showing you how it works, and that making statements in the video. Now, there's a key word in that, is that it has to be an affirmation of fact. It can't be that, my product, the X2000, is the best on the market. We all probably think that's a fact, but a court's going to say, well, that's the kind of thing companies say about their product. Of course they think theirs is the best in the market, but is it really a fact? But if you have a video that says it'll do X, Y, and Z in under 20 seconds, and it can't do it in under 30 seconds, well, that's a fact, and that would be a warranty. And if the video said that, you probably would be stuck under the first section of it, which says you can't. Let me see if I can go back. So they saw a video of what your product and what it looked like. I think you might have a real problem under that last section. Yeah, just because you're not there live with it, it could very well be a sample or model. It's a great question. You know what the scary answer to that is? The jury gets to decide that ultimately. So your jury of 12 or 6 people who have no accounting or economic background are going to decide that. There is some law that says that if you're going to seek lost profits, you have to deduct from your revenue amounts the amounts you would have had to expend to get to those profits. That's something you have to take up with the judge prior to, and you generally have a good chance of that. So plaintiffs, the people suing for the breach, are generally going to sue for the lost revenue and just try and avoid that, and they'll throw everything in there, and they'll try and confuse the jury, and they'll stand up in front of a whiteboard and say, here's the amount we would have earned, and it will ultimately be for the jurors to sort out what's the real world practical impact. Here's what they really would have earned versus what they wouldn't have. And I don't mean to besmirch jurors. You saw a couple of the ones that are a little bit ridiculous. The 1.5 million profits over a 3-month period for a new grocery store seems a little stretched to me. But there are other times that they do that. But it's a matter of argument. It's a matter of argument for the jury. Oh, that's exactly the way the system's supposed to work, is the parties working it out ahead of time. Anybody else? I'm far away. It's a free shot at a lawyer.
Is it possible to ensure consequential damages?
Oh, that's such a great question. And it's the way the Uniform Commercial Code is not uniform. There are some jurisdictions that will say, let me start at the real beginning part. Insurance law generally says that you cannot insure contract breaches. And the reason for that is you can't generally insure things that are under your quote-unquote control. You can insure negligence claims, personal injury claims, those types of things, because they're injuries, those types of issues. So the courts in the 50 states have all come to different results on the insurability of that. Some have said that, well, I mean, it says personal injury right there in the UCC. I could go back a couple slides, but it says a consequential damage includes injury to person. That sure sounds like your standard personal injury suit. The $8.1 million KFC lawsuit, sure. I mean, we've got a little girl who had a brain injury. Doesn't that sound like a classic insurance situation? Others had said, well, the UCC is a body of contract law, and contracts are not, can't be subject to insurance. So I guess the long and short of it is the jurisdictions are split fairly evenly. I can't say it's 25-25 amongst the states, but it's somewhere in that range. So it's really going to depend on your jurisdiction, which gets us back to choice of law and choice of forum. It can end up really, really mattering. And unfortunately, this has been an issue that's been considered outside the ambit of the UCC drafters. They have been asked to get involved in this question, and their answer is, we're not in the business of insurance. We don't really know all the nuances. We just want to stick to commercial law and duck our heads away from what's a really big question. Because if your claim is insured versus non-insured is, usually it's a starting point. And if your consequential damage claim isn't, you're the one on the nose, and it's a far more dangerous claim. But unfortunately, I don't have the best I can do is to say it's split evenly, and it's going to depend on what state you're in, or what state laws apply. Yes? That would be one way to do it. You could say that this creates no warranty. Yeah, whether that's enforceable or not, I don't know off the top of my head. I think that's what I would probably advise as the necessary first step. Maybe not going too far in the video would be, I don't know if that's practical or not, but as a lawyer, reviewing it and saying, well, just be careful what we say is probably the necessary second step. But a disclaimer, and again, and particularly when it kind of depends on the audience. I think with our customers, when you have sophisticated, what the UCC describes as merchants, which is a buzzword in the UCC for not consumers, so somebody who's more sophisticated, the playing field's a little different. And so amongst merchants, amongst sophisticated commercial entities, a disclaimer like that's going to carry some weight. If you were showing the same video, if it was a different type of product that might be sold to somebody on the street, that disclaimer probably wouldn't work. But if your video is going to people who are generally the customers in this industry, it's likely to be upheld. But I don't know of any cases that have dealt with that explicitly, or the video question in general, which I think is an excellent point. Maybe a new branch of litigation, we'll see. Yes? Oh. I'd like to say I do. I'd like to be able to give you advice, but I think I would be walking further out on the plank than I'm comfortable. The IP world is a whole different animal, and it's just so against my nature to be modest, but I can't give you a good answer. It goes against lawyer DNA to admit that, but I don't want to give you advice that I don't think would be 100% true. Unfortunately, I'm certain that's something you're probably seeing more and more, but it's not something I have enough knowledge to discuss intelligently. Anybody else? Well, thank you. I really appreciate getting to speak in front of this group. It's been an entertaining discussion, and I appreciate the opportunity.